Hey everyone, and welcome to my Q&A. This is January 2026, and I am going to be talking to you about the new process for the H-1B cap lottery for 2026, fiscal year 2027. Hard to believe we're talking about 2027 and it's the beginning of 2026, but here we go. In this Q&A, as with all my Q&As, what I intend to do is actually I collect the questions that I receive from you, our clients, our listeners, our followers, about issues that are of importance to you. And then I review them and I collect and answer the ones that I feel that are going to be most helpful for the community, for all of us that are here. So, uh, with that in mind, again, the topic of today is going to be the H-1B cap process, which is literally one of the biggest procedural changes that I have experienced in my career as an attorney, and particularly during the as part of the H-1B cap process. So again, this new cap process is one of the biggest procedural changes that I have seen in my career. And interestingly, has been the one that have potentially received the least amount of attention um, from the government in relations to the comments that were made pro against the rule. So here we go. With that, and actually before I cover your questions, and I've selected four of them. I want to give you a little bit of background just in case you're jumping into this Q&A and you're not really sure what I'm talking about. So, a weighted wage H-1B cap selection process is expected to take effect for the fiscal year 2027 H-1B lottery. Well, we technically will still have a lottery, and the lottery happens if there is more registrations than there is visas available. And the cap for those visas has not changed. It's still 85,000 H-1B cap visas available. If there is more than 85,000 registrants, which has been the case for, I want to say 10 years or so, then a lottery occurs in order to award those visas. So that the the lottery is likely to happen. The 85,000 cap is still the cap. What has changed is the way the selection process will take place. And this has been something that this administration and during the prior Trump administration they have been talked about, they have tweaked, they have, attempted to implement in various ways. This is the closest that we have gotten to implementation, and that is what I'm advising clients to plan for as we go into the planning period, which is some of the questions that I'm going to be answering, what to do. The way the process is expected to work is that under the new rules, higher level wages are going to receive more entries into the lottery. If you're familiar with the 20,000 H-1B caps that are reserved for the master level US masters, so there is 85,000 total. 65,000 are regular cap, that's everybody, and then there's 20,000 that are reserved for US masters. Well, those US masters typically get entered into the lottery twice. So they have a little bit of a better chance of getting selected. That doesn't change necessarily for this process, but in addition for this new process, but in addition to that, what we're going to see, and the wages, the way the Department of Labor has structured the wages is in four levels: level one, level two, level three, level four. Level one are your entry level positions. Level two, a little bit more advanced. Level three, a little bit more advanced. Level four is the very experienced professional. And those level fours have the highest wages typically. So the lottery is expected to work that when you put in a registration for a candidate, if that candidate fits the level four category because of their duties, skills, and wage, they will be entered into the lottery four times, which obviously increases their chances. On the other extreme, if we have a level one person, someone that is, an entry level position, they will enter into the lottery once. So a benefit in a way, if we can look at it as a benefit, because the prior proposal of this rule during the prior Trump administration had completely eliminated the ability of employers to enter level one and level twos into the lottery. They were just, all the visas were taken away by the level threes and fours. But now the level one doesn't completely disappear, or two, they just have lesser chances. And there are many, many, many other factors that come into play. So I want you to keep that in mind, front and center, because this is one piece of the puzzle in this very complex and ever evolving H-1B cut process. And I also want you to hear me clearly, and ever evolving, because as I speak to you right now, the most that we know is the proposed or the rule that is out there. Nothing more. There hasn't been an FAQ, there hasn't been any guidance. We don't know when the registration is going to open. All of those are uncertainties at this point. I know those are questions that you're asking me, but I don't have answers for now. So this conversation will continue. For now, I am going to give you the answers that I do have and perspective. And I also want you to know that every Wednesday going forward, so the following Wednesday from now, I'm going to be releasing a newsletter all about the H-1B cap, where I'm going to be giving you some updates if we have, or clarifications if we have them, and more of more content than the one that you're going to hear today. And then the last Wednesday of the month, I am going to be releasing a resource of the month. And that resource of the month is going to be an infographic that is going to be visually appealing, practical, that you can use as a guide for your decision. And this is my gift to you, to help lessen the anxieties, give you peace of mind, and you can just have something that you can look at and kind of say, okay, I get what is next, instead of you know, looking at millions of sources. Okay. So with that in mind, let me tell you the questions that I've received and selected and my guidance. What is the most important thing HR should do in January to prepare for this new process? Now, if you're one of our clients, I have already started providing information. So they're already, quite a few of them are already working on some of these. But my main recommendation to you is do not sit on the sidelines waiting for the next piece of information, waiting to potentially things to change. They will change, but you have to start now. There are many more decisions, strategical decisions that will need to be made this year to enter someone into the lottery and register them. So, because of the ongoing changes, if you don't have the foundational pieces that I'm going to be talking to you about right now in place, it is going to be very difficult for you to shift if you need to shift later on because you won't have foundation to shift from. So, my main recommendation again, more than ever, more than any other prior year, start now, be proactive. The strongest position is going to be to be informed as best as you can. So follow someone like me or someone else of your preference, but just stay informed with someone that can give you practical advice and not noise. Be prepared, be flexible. The guidance will continue to evolve. That is not going to change. The one thing that is not going to change is the registration period when that opens, and it's likely to be in March. So once that is set, there is no changes. And if you're not ready, you lose and your candidates lose. So for each potential registrant, these are the things that I want you to start looking at and document it very clearly that you can send to your attorney. Job description, core duties. So title, job title, and the core duties that go with that title. The work location. That is going to be very, very important because wages are assigned in a general sense based on the location of the work site. So wages, for example, in Florida may be lower than wages in New York. Standard of living, who knows? But that's the way it works. So work site location, and then something that you potentially don't know, but your attorney is going to help you strategize on is the SOC code. That's the occupational code that we need to assign each job, H1B job with, and the wage level that the Department of Labor associates with that code. Again, that's the piece that you need to work with your attorney with. So on your end, title, core job duties, work location. And actually, I need to add to this the wage. The wage that you intend to pay to that worker, and this is a tip. The wage that you expect that worker to have October 1st, 2026, because that's when the H1B cap, if the person is elected, that's when it takes effect. So that is what is really significant for you right now. Not the wage that the person, and this is one of the strategies that I'm talking to our clients about. Many, many of your workers will receive likely a raise of some sort between now and October 1st. And if so, that is what you need to be looking at to see what wage level, remember level one, two, three, four, it will apply. Okay. No one, no one knows exactly how this is going to play out, even the government, because there are so many pieces at play. The math and the chances will continue to shift and evolve. So, again, my strongest recommendation to you is to start planning now. Get that data that I just asked you about in place so that you know it, and start working with an immigration attorney that you trust and has experience in these cases so that you can be as successful as you can. Okay, next. Will the H1B lottery include this 100K fee for all registrants? I'm actually to some degree surprised that I've gotten that question a lot. And I believe is a reflection of all the confusion that is going around and the noise that sometimes prevent us from hearing what is behind the noise. Now, again, with the caveat that everything is evolving, at this time, the 100K, so that is that new added fee that got tagged into the H-1B cases September 21st, 2025. The 100K is not supposed to affect new H-1B cap petitions that are being filed as a change of a status. In my case, that is about 90% of the H-1B caps that we file, meaning these are foreign nationals that are typically in the United States. Many of them are going to some of our best universities, and I could say UF near me, University of Florida, University of Miami, UNF, University of Florida, all the way to, Harvard, Yale, Boston University, MIT. I mean, we have very, very, very talented foreign nationals in this country going to our best universities, contributing to our economy. And they are typically in F1 status. So they're going to school. After they graduate, they receive an employment authorization document, and they're typically working with my clients with that employment authorization document. And it's at that point that we enter them into the lottery because they will be going from an F1 to an H1B. They will be applying for change of status in the United States. And as we speak, as we know today, those H1B cap petitions will not be affected by the 100K fee. The 100K fee will apply, or is expected to apply, to the H1B cap petitions that are filed for registrants that are abroad coming into the United States. Or they could be in the United States, but for some reason they cannot change status in the United States and they have to consular process. Those will be affected and potentially will have to pay $1,000, $100,000 to enter or into the lottery or after they get selected, I would say. Okay. Now that is going to have a significant impact, we think, on how many petitions from abroad are filed. And also all the uncertainty that is going on right now could have a significant effect as to how many registrants are entered all around. So all of those things are factors that could shift the odds one way or another. And that's why I continue to say, get in the game, prepare to enter your registrants. Um, Third question, is this still a lottery or is it a pay to play now? Is it a pay to play now? Well, some may say yes, but reality, it is still a lottery. Again, as I mentioned before, it is no longer neutral. It is heavily weighted towards higher wages. They will have better statistical odds, the high wages, but not a guarantee selection. And the lower wages are still eligible. And who knows? Again, we may be surprised as to how this turns out. Again, because of there's so many variables and the unknowns, and we won't know until literally the lottery runs. Get in the game, get prepared. Last but not least, um, how should employers adjust their planning under the new system? I'd I want to say, even though I'm repeating myself, but it's worth repeating. The best plan is planning deliberatively, proactively. Okay. So, some tips here: evaluating the wage levels, evaluating where your candidate would fall into the level one, two, and three, four categories. You need to do that with an immigration attorney to guide you and make the best selection. Um, again, considering whether a raise or a evolution, a role evolution to a different position will play a role. This is all strategy that it will require time and energy and money as you prepare. Confirming the website, the web work site, and also tightening the documentation around the roles and the job description. Again, it is imperative that you work with an attorney to get this all in place. Okay. So I hope that this has been helpful. Again, many pieces at play here. We won't know what the 100,000 fee will do. We don't know how many employers will really register people. This will continue to evolve. But again, my strongest recommendation to you is start early, work with a trusted immigration attorney, remain flexible, and have a strong foundation so that you can pivot. And that is it for my Q&A for today. Again, be on the lookout for the newsletter that will be coming out next Wednesday, and that will continue to provide some of this information, but additional information that I have for you and the resource of the month at the end of the month. Thank you for being here with me. Thank you for your trust. Thank you for your perseverance and understanding that global talent is critical for our country so that we can continue to be the strongest and best nation in the world. Take care. Talk to you soon. Bye bye.